Sure. Do you want to get started?
Okay. Okay, if we could all take our seats. I'm Kent Roach from the Faculty of Law here. Welcome back for the judges panel. Our first panel today, you could tell they were all well-disciplined interveners because everyone kept their remarks short, and that allowed lots of questions from the floor. So we'll see if the judges can also duplicate that experience. I really feel like the announcer at an all-star game here because I really couldn't imagine a better panel to speak to judicial perspectives on interveners. Our first speaker will be Justice Frank Iacobucci. The lawyers and the law students in the audience you've all read, and we've already heard reference to Justice Iacobucci's many landmark decisions and impassioned dissents when he served on the Supreme Court of Canada from 1991 to 2004. You may not know that Justice Iacobucci is a great friend to the law school and University of Toronto in general, having served as professor, associate dean, dean, vice president, provost, and interim president. I think that's almost all the important jobs at this institution. And Justice Iacobucci will be our first speaker. So.
Thanks very much, Kent. It's really a pleasure to be here in this conference and commend the Asper Center and its leadership for putting it on. And it's just great to be with Kent and these two wonderful friends and judges of this great province's highest court. And I will start off with a disclaimer, and that is my remarks are those of only myself now. But then when I thought about that disclaimer, when I used to speak when I was on the court, I used to speak only for myself quite a... and on those wonderful occasions, like when I got four others to go with me, I could speak for the court. But anyway, they're my reflections, and secondly, I have to say, I'm going to repeat some of the themes that we heard in that wonderful first panel with the those individuals who have had a lot of experience with the court. My perspective will be perhaps a little different, but it really comes out to similar comments that they made. Let me just give a little history, a modern history, about the Supreme Court and interventions. In the 70s, the court was really quite somewhat not attacked, but certainly a lot of efforts were made to try to get the court to loosen up on interventions. The Canadian Bar Association was very active. There was a reluctance to get involved in interventions, and that reflected, there would hardly be any criminal cases where you would see an intervener, and it was rare for civil cases. And maybe it reflected, I don't know whether others have said this, but it reflected, I think, something of the English court's attitude. If you, I don't know if it was Denning who's someone, I think it was Denning, but who talked about the busybody, an intervener being a busybody who's really getting involved with business he doesn't have anything to do with, or something to that effect. But the court, to its credit, did open up toward the end of the 70s. And in fact, I think that was also reflective of a great development in the court's work, really. It wasn't just charter cases that were the only areas in which the courts made an impact. There were some wonderful cases from the 70s. But the real breakthrough comes with the charter. and I'll speak a little bit about that. But let's go back to the rationale for having interveners, and I think there are several, or a number. First, useful or helpful to the court, primarily because in many areas, the courts, I don't believe, can just rely wholly on the adversarial system to bring out the matters of help or background to the issues that are before the court. Parties' counsel have to really focus on primarily on their client's best interests, and they really have to focus on that result. Nothing wrong with that, but that's the way it is. So that's utility, and then secondly, just following on that, the interveners do provide a different or fresh perspective from that of the parties. I mean, it just follows from the first point, and that can be further elaborated that interveners may have a special interest, special experience, special knowledge, special expertise that enables the court to take a long-term view of the case. And here we come to what I believe are the functions of a court decision. I remember former Chief Justice Boral Askin visiting this law school and making this comment that I'm going to repeat. Namely, a court in a case is looking at, especially the Supreme Court, is looking at the decision, that what's the right outcome in that particular case, but is also looking at the development of jurisprudence for the country's legal system as a whole. And it's on the second one that interveners can be so important in playing a role for that, or the policy development aspects that one of the, I think it was Frank Addario or the earlier panel emphasized. And then another rationale is I believe it's very important to have some way of in carrying out the court's function to legitimize the decision of the court. There are ways in which courts have badges of legitimacy. I say this a lot. And one of those badges of legitimacy, that is to say, why do Canadians accept decisions of the court? Now, don't agree with the decisions of the court. That's not. But why do we, as a democratic society, accept work of the court? Well, there's a lot of reasons for it. One of them is the process that they use is a fair process. You let the parties argue, and it's all in open court, and so on and so forth. But that, I think, the intervention is part of that kind of legitimating attributes that are accept that there are views that others can participate in with special background and knowledge. And Nathalie Desrosiers, in a paper she delivered last March, she wrote about this, and this came up in the earlier discussion, the democratic empowerment by bringing voices and opinions of representatives of the demos to provide input. Now, I think that has its attractions and it has its shoals of concerns. You don't want to transform the court proceeding into a political, purely political process. It would be wrong, but there are interests. When you're starting to look at the issues that are before the court, then that kind of contribution is very important. But when we come now to the Charter's impact, this was a tremendous boost to interveners in our country. But let me just say the opposite. I have no doubt that the role of interveners, particularly at the formative start of the Charter litigation and Charter jurisprudence, was absolutely invaluable. Just no doubt about it. And I'd say, if I just wanted to carry that comment forward, I was saying earlier that the number of cases where interveners were not helpful or problematic and so on and so forth, there are some, and they have to be, those mischiefs that create that problematic use of interveners have to be looked at and have to be considered. Having said that, the number of cases in which interveners played a real role in the jurisprudence of the Supreme Court of Canada is pretty substantial. I was thinking about this anecdotally, but I could go on for some time talking about the impact, very positive impact, in the development, and I would say in particularly of great importance. This was a new set of constitutional values, and LEAF, CCLA, the CLA, EGAL, and many others played a formative role. Why is that? Well, you look at legislative and adjudicative facts in charter cases. The adjudicative facts of who did what, when, why, etc., the normal kinds of questions you ask in specific cases. But the legislative facts, the policy ramifications, what does it mean to say freedom of expression, the sort of appearance of the Brandeis Brief in the Canadian context, the polycentric issues that required views from other disciplines that Doug Elliott mentioned, getting the views of social scientists and so on. These just are absolute invitations of participation for intervening groups, in my view. It was really important to have that. And if you think of the very difficult questions of the judge as a quasi-god, by that I mean abortion cases, euthanasia cases, assisted suicide, but other areas of the interaction of law with other disciplines, then it's really, really important to have an ability to draw on those disciplines. And they have been very, very important in the development of the jurisprudence of the court. Political scientists, sociologists, and philosophers been very, very important. And I would say one of my themes is that once you have the charter, there's always been, in my mind, a spillover of charter approaches into other areas of the law. I think the reliance on international precedent, the reliance on comparative law, the policy arguments, looking at theory, looking at academic work, whether it be by the professors or students, which has been done tremendously in charter cases. It's also been done in non-charter cases. And similarly, you get the same kind of thing in, to a less extent, but I think this charter has influenced the criminal law and the civil cases. So that was the boost. But then there's been a retrenchment, has been the use of interveners, as others have commented on. And I think that retrenchment was all about trying to get the balance right, trying to get the best out of interventions without introducing some of the disadvantages of using interveners. There was the point that was made by Frank Addario, and I agree, and that bothered the court. That is having interveners of AGs occupying one half of the courtroom and the lawyer for the accused lonely sitting by him or herself representing the accused. It was just an uncomfortable feeling for the court to see that kind of lineup of a whole bunch of interveners on one side or the other. There was also a concern about extending the case. And this causes a lot of waste of time and money, because if you're starting to put in new issues, or if you're trying to get in new evidence, then people are bringing motions to strike this factum or that factum, and then it obfuscates rather than clarifies the issues that have to be dealt with, and it, again, operates as an unfairness. If the parties' counsel have to be dealing with putting out all those fires, that another one that was raised is the speech giving. This is the partisanship. And it's too bad, but there have been just a lot of speeches given as opposed to. And by the way, I'm not picking on the non-government. Sometimes the government side can be equally sinful in that respect. Repetition of views constantly, just repeating. And then Justice Major, some years ago, wrote something for the National, and he said this: the value of an intervener's brief is in direct proportion to its objectivity. Those interventions that argue the merits of the appeal and align their argument to support one party or the other with respect to the specific outcome of the appeal are, on this basis, of no value. That approach is simply piling on and incompatible with a proper intervention. The anticipation of the court is that the intervener remains neutral in the result, but introduces points different from the parties and helpful to the court. Now, I think that is a fair statement and reflects a concern. I'm not in a position to deal with the recent changes that the court has made. I don't know how that's working out, but I know that if you look at the application for intervention now, it's different from what it was some time ago. You have to show why, and there's suggestions of how you get to you ensure your rights to intervene, and at the same time, there are many more hurdles to get that, and even greater hurdles, I suppose, or more hurdles to get oral argument. And when you get oral argument, it's been reduced now to 10 minutes and 10 pages. I'm not in a position to say whether that is the right response to the concerns and to the mischiefs of not having effective and helpful interventions. A few minutes on best practices and I'll stop. First question I think you ask is, do you really need to intervene? Because you answer that question, what value will you add? And really think about that question. What value are you going to add to this? And then following up with what Justice Major said, be objective. You know, this is not the only area where you're being objective. You see in expert witnesses, the same kind of thing that's developed in the law. Justice Coulter Osborne, I think his recommendation was supposed to come into effect in the new year for experts to be, and Justice Goudge's inquiry is wonderful on expert, fantastic. It's a tremendous contribution. That is, experts should be helping the court, not just the parties that pay them, to get away from that battle of the experts. Well, here, be objective if you're an intervener. I would say think really hard about the strongest points to argue. Not that goes for advocacy generally, but particularly with interveners. You don't have to think that you've got to. And the third thing is get together, whether it's in Franco Dario's hotel room or otherwise. I think that's very, very important. It really, really adds a lot to see that happening. I know it's difficult, but just teleconferencing is not difficult nowadays. Surely you should be able to think about that. And the fourth thing I'd say, don't waste the time of the court. If you've been taken up, if your point of view has been said by a party or a previous intervener, gee, it really is wonderful to hear an intervener get up and say, I was prepared to talk on a point, but it's been so eloquently done by Nathalie de Rosier that I will sit down. And because you'll be going back to the court. You won't. Most of you will go back if you're doing interveners, and you want to be conscious of your relationship with the institution. as well as representing the organization that you're appearing for. And then the fifth one, no speeches. As I say, no speeches. There's so many. And the good, wonderful interventions, some of them have been raised, Sharp, Butler, Green, the Quebec secession, which again, references are different to some extent. You really need interveners there. I'll stop. I'm sorry if I've gone over my time.
Thank you very much. Our second speaker will be Associate Chief Justice Dennis O'Connor of the Ontario Court of Appeal. Before being appointed to the Court of Appeal, Justice O'Connor was a leading lawyer, litigation lawyer, served as a bencher of the Law Society of Upper Canada, and is also known for running two excellent public inquiries, the first into tainted water at Walkerton and the second into the Mayor Arar case. So, Justice O'Connor.
Thanks, Kent. And let me join with Frank Iacobucci in commending the ASPR group for putting on this program. I think it's a wonderful idea, and I commend you for coming to it, and am indeed pleased to have been invited to participate. I agree with what Frank has just said with respect to the basis on which parties are granted intervention. Let me put it this way. In the Court of Appeal, the test for being granted intervention sounds very much like what Frank just explained. The value of interventions is the same. His comments with respect to best practices and so on. There's very little difference what he has explained as to the way things operate in our court. But let me just give you some of the things that some of the information about interventions in our court that may prove interesting to you. As you probably know, there's two ways under the rule to apply for interventions under the Ontario rules. The first is as a party, and that's somebody who's directly affected. When we're talking about public interest interventions, it's not usually going to be an intervention as a party. The second is as a friend of the court under Rule 1302, and in the rule it's for purposes of assistance, providing assistance to the court by way of argument. And applications in our court are made to the chief or to the associate chief or to a panel. And the long-standing test is the one that former Chief Justice Dubbin set down, is general, it's flexible, it's common sense. You look at the issues, you look at the expertise of the parties, the things that were just mentioned, you look at whether there can be a valuable contribution, and you're also, indeed, the court will look to see if there's any potential prejudice. So that with that general test, the court person hearing the application will then move to the specific case. In preparation for this today, I looked at the statistics of our court granting interventions, and I thought it was kind of interesting. Starting with 2001 through the present year, we have nine years, and we had over that period of time 156 applications, or approximately 18 a year. We granted 131 of the 156, which is somewhere in excess of just above 85% of those that apply. I don't know how many were opposed. I do a good number of them. My sense is probably something less than half, but close to half would have been opposed. So that I think one just looking at the raw statistics would conclude that we are quite liberal in granting interventions. We hear between 1,000 and 1,200 appeals a year, so that the number of cases in which we have interveners is a very small percentage. I think, but a good deal of the work we're doing is really error correcting involving criminal cases or civil cases, and wouldn't be the stuff that would attract interveners. Of those granted, 93 were in civil cases and 38 in criminal cases. And of the ones that are granted, I think it's fair to say that they virtually all have a public interest component. and the vast majority of them come as friends of the court, so that they fit into that type of case. Now, in some cases, and I think this is important for an audience like this, in some cases there have been grants of intervention status below, but in most cases not. If a person's been granted intervenor status as a party below, automatically they will have the same status in our court. If they've been granted intervenor status as a friend of the court below, they have to reapply, but I would think it would be virtually certain that they would get in, having got in below. But the important point is that being an appellate court, when we grant intervenor status, generally one of the conditions is you take the record as it is and that you do not raise new issues. Not automatic, but generally that is the condition. And the reason for that is, first of all, the concern that was mentioned before, that if the case is expanded by way of issues or evidence, it can operate unfairly to the direct parties to the litigation. Their case becomes someone else's case. That's a concern. It's not fatal, but it's something the court pays attention to. The second reason is that the Court of Appeal, while we can hear fresh evidence, and we do in some circumstances, is not the ideal forum for developing evidence. And so that while I appreciate the difficulties I heard at the end of the previous discussion about the costs of intervening at first level, it strikes me that if an intervener wishes to have an opportunity to call evidence, expand the record, rather than take it as given, there is going to be a much better chance of success in doing that if you do it at first instance, rather than when you get to our court, and perhaps even more less likely, I'm not sure, but my guess is even more or less likely at the Supreme Court of Canada. So as you go up the ladder, that fixed record becomes more concrete and less opportunity to change. Like the Supreme Court of Canada, interveners have played a very important role with respect to the development of constitutional law in our court, and for the same reasons. They bring a different perspective. Chief Justice McMurtry, when he was dealing with intervenor applications in Arthurson and other cases, spoke frequently about the value of the different perspective that interveners bring and granting intervenor status for that reason. I would add, though, to that I also think, in my experience, interveners can make a real contribution with respect to identifying the impacts of policy changes, charter litigation or otherwise, that may result from a decision of the court. Advocacy groups often have the expertise, have studied the trends, are aware of the social issues. And so that when a court's looking at a new policy development, one of the concerns has to be the ripple effect as it spreads out and the effects intended, unintended, or unforeseen. And my experience in dealing with intervenor applications is advocacy groups often bring a lot to the table in terms of that. And I think a good example of that would have been Halpern, the same-sex case. The narrow issue in that case was registration of the marriage. But then the broader implications of doing that as they spread out had to do with property rights and other obligations for support and so on. There's a whole range of other issues that came into play. And the court, and our court, I think, was particularly well served by there having been a number of interveners, and there were some in the court of first instance in that case, but very well served in having a full discussion of the ramifications of what the court was being asked to do. So that if you talk to the judges who were in that case, they would say, interveners, home run. Thank you very much. We really appreciated the help. They didn't, however, in our court, as I mentioned before, expand the record. And so that was, they did it took the record as it was. It's not automatic, however, just because it's an advocacy group who applies, that there will be a grant of intervener status. As Frank pointed out, the court needs to be satisfied that there is some value added. Admittedly, interveners don't take a lot of time either in terms of the paper, the factum, or the oral argument. There are usually limits put on it. But it is essential in making the application, and I hear a goodly number of them, to include as best you can what the value added is going to be, the different perspective and so on. And I think the numbers reflect it, that once you show the value added, in the vast majority of cases, you're coming in. And so that, but occasionally, in fact, in Arthurson, the one I spoke of earlier, Chief Justice McMurtry, having set out at length the value of interveners, actually found no value added and turned down the application in that case, found that the points were being made by others. Let me speak briefly about criminal cases in our court. The statistics, as I mentioned, show that there's fewer interventions in criminal cases than in civil cases. I'm not sure exactly why that is. We hear approximately the same number of civil and criminal appeals a year, but there's more than interventions and more than twice, almost 3 times as many in civil cases. One of the reasons, it strikes me, is that we are very careful about allowing interventions on the Crown side of a case. There can be difficulties with fair trials for an accused, and I gather I didn't hear it. Frank Addario mentioned the prospect of an accused sitting there and having an array of attorneys general on the other side of the courtroom. In a constitutional case in the Supreme Court of Canada, that may be inevitable. But we do get some applications from even advocacy groups in criminal trials. And when they come on the Crown side of the case, I think I'd put it, it's not an absolute, but we're very careful not to tip the balance against an accused person. We get interventions, constitutional cases. Regina and AM, the dog sniffing case was an example of one recently that has gone to the Supreme Court of Canada. We had the Canadian Foundation for Children, Youth and the Law intervened with respect to the reverse onus in youth sentencing. Valuable perspective on that. But we have a second. Those types of cases almost inevitably end up in the Supreme Court of Canada. So that the groups that intervene in our court, constitutional cases, it's just the stage before the big show.
Spring training.
Yeah, that's right, spring training. We turn it over to the smart guys. We're sort of like a setup picture in the 8th inning. But there's a second category of cases that we get an enormous amount of help in interveners in our court that most often don't go to the Supreme Court of Canada. And those are with respect to matters in criminal law, sometimes civil litigation, but relating to procedure or process in the courts of Ontario. And in these types of cases, the Criminal Lawyers Association, occasionally the Crown Attorneys Association, but the Trial Lawyers, Ontario Trial Lawyers Association, the Advocate Society, intervene and have made great contributions. Felderhoff is one case dealing with the permissible conduct of counsel and judge in a court, and Mark Rosenberg's judgment is sort of a landmark decision in Ontario. Crown Attorneys Association, criminal lawyers were in that. Whether paralegals can represent clients in criminal cases, whether a prejudged trial can sit on the trial, whether costs can be awarded against an accused who's brought a failed application seeking third-party records. We've got a whole string of cases, important cases, where we need the expertise of the practicing bar, and sometimes we actually call for it, and it's every time, without fail, they step up, make a huge contribution. So that it's a different type of public interest than a lot of the advocacy groups, but a very important one indeed. The final group of cases that I'll just touch on are private law civil cases that we're reluctant to, when it's just a strictly private law civil case, to unbalance the scales by having interveners on one side or another, unless there's a public policy component into it and the law is moving into a new area. One was Childs and Desormeaux, which was the case of the host responsibility for an impaired driver leaving his house and injuries caused. MAD, Mothers Against Drunk Driving, was allowed in that. We've allowed in a private litigation with respect to residential tenants. We've had a tenants association come in because of added something with respect to the relationship between landlords and co-tenants. And recently, in a case some of you may have heard of, we had a 5-judge panel re-looking at the issue for Ontario courts assuming jurisdictions over torts committed in other countries. And the trial lawyers and actually the Tourism Association came in on those. So that when there is an important public policy component, we get benefit as well, non-constitutional cases from interveners. So just to wind it up, I think applications for intervention are warmly received by our court by and large. When they come in, the standard conditions will typically be a limit in the number of pages of the factum, typically 20 or less, depending on the issues. Limits on the time for oral argument, often 15 minutes, possibly longer if depending on the issues. We make orders that typically there'll be no costs for or against an intervener, and often, as I mentioned earlier, that the intervener not be permitted to expand the record. So that's how it works in our court. Thank you.
Thank you very much, Justice O'Connor. The cleanup hitter for our all-star lineup is Justice Stephen Goudge. Justice Goudge is a graduate of this law school and has gone on to be a great friend to the law school, teaching many subjects for us. Like Justice O'Connor, was a leading litigation lawyer and elected bencher of the Law Society of Upper Canada, and has been on the Ontario Court of Appeals since 2000. No, sorry.
You don't need to give the date, isn't it?
Anyway, okay. Without further ado, Justice Goudge.
Thanks, Ken. Well, let me cover this fairly quickly, so there'll be time for questions of Frank and Dennis. Speaking of public inquiries, I think the history of interventions in public inquiries in Canada is a proud one. I think over the course of the last 100 years, many inquiries have seen interventions that are enormously valuable and important. I think back to an inquiry I was involved in a generation ago involving the Mackenzie Valley Pipeline inquiry, which had a dramatic effect on the development or non-development of energy in the north of Canada, where the result was very, very largely affected by the interveners on behalf of the Aboriginal people in the Mackenzie Valley and by environmental groups. And I think that kind of participation has been reflected in a number of inquiries that have taken place in Canada. And perhaps compared to interventions in court proceedings, the approach to interventions, I think, in public inquiries has probably been more expansive, more liberal. Easier to acquire standing, and perhaps easier to have a standing that's relatively expansive. The framework, the legal framework in which interventions occur in public inquiries begins with legislation, encompasses the order in council setting up the inquiry, and includes the ruling on standing that the commission almost invariably makes. Legislation first. Legislation exists in every province and federally to deal with public inquiries. They are set up under under legislation. That has set the framework for the history. I'm going to comment briefly at the end on how that may be about to change significantly. Suffice it to say that historically interventions have encompassed one of two things that appear in legislation. First, most legislation provides that if a finding of misconduct is going to be made against somebody who is the subject of an inquiry, that person has the right to notice and to attend and participate. That's a due process requirement that exists in virtually every underlying piece of legislation under which inquiries operate. Secondly, there is a provision in many inquiries, like the one in Ontario, at least to date, that requires that any person who has a substantial and direct interest in the subject matter of the inquiry, that's a quote, have the opportunity to give evidence and to call or examine witnesses relevant to the person's interest. So the catchphrase there is, if you have a substantial and direct interest in the subject matter of the inquiry, the legislation gives you a right to participate. So you got the two ways of getting into an inquiry. One is your ox is going to be gored, possibly, and the other is you have a substantial and direct interest. The order in council often provides for something that usually doesn't happen in litigation, and that is for some kind of provision for funding of interveners where they would otherwise not be able to participate in an inquiry. That's not always been the case, but currently I think it is typically the case. It certainly was in the inquiry that I did in Ontario. Then in almost every case of an inquiry, there is a hearing about who shall have standing and what the terms of that'll be, and the commission decides on those two questions. So that's sort of the legal framework. What are the guiding principles? Well, like Frank and Dennis, I'm just going to parrot what Dennis said in the Walkerton inquiry. For commissions, I think there are really two guiding principles. One is inquiries must be thorough and inclusive, and the other is that they must also be expeditious and efficient. And so those are guiding principles that determine a whole lot, including interventions and their scope. What are the purposes of standing? And Nathalie DesRosiers outlined them in the paper Frank referred to, and I think it's a helpful categorization to help the inquiry, to legitimize the inquiry, and in some sense to embody democratic participation in the work of the inquiry. Let me just use my own inquiry as an example of what I was guided by in sort of unpacking this notion that I was required to unpack of substantial and direct interest. Obviously, the order in council set up the subject matter of the inquiry I was to deal with. It characterized it as a systemic inquiry, which meant that some regard had to be had for interveners who could contribute to a discussion about the systemic issues and how those issues could be addressed in the future, and the timeline of the inquiry, which speaks, that was in the order in council under which I was required to operate, which speaks to the need for expedition and efficiency. I also looked at a sort of modification or rephrasing of Nathalie's criteria. Individuals or groups who could be significantly affected by the work of the inquiry or the report of the inquiry. Individuals or groups who had information that could be helpful to the inquiry, and the need to ensure that we would proceed as relatively efficiently as possible. Inquiries have techniques for tailoring interventions and have done so historically quite explicitly. Many inquiries operate in two phases. They have a fact-finding phase and a policy phase, and it's quite common for interventions to be focused by the Commission on one or the other, or both, but that allows some tailoring of the intervention by the Commission. The participation can be tailored in other ways. The order in council itself can do it. The order of the commissioner can do it. For example, we had an intervention where the only issue at stake for the proposed intervener was a new trial that had been ordered for the intervener, and the intervention was limited to evidence that could possibly be relevant to the new trial as opposed to the rest of the information we were gathering. Interventions can be limited by grouping those who are commonly interested. That's the Doug Elliott-Frank Addario combination, where you get like-minded or similarly situated individuals or groups who are required to combine their forces in a single intervention. A technique that inquiries have used, that I used, was to tailor the participation of interventions by the time limit of participation. That's a fancy way of saying how much time was available to interveners to examine various witnesses and to make submissions. So time limits is another way of doing it. Best practices, like Frank and Dennis, I think interveners have a hugely important role to play. The potential for assisting the Commission is huge. It requires focusing on and understanding the mandate of the Commission, emphasizing the special knowledge the intervener brings to bear, avoiding duplication, and being as efficient as possible. Certainly my own experience was that I was blessed with interveners, all of whom were represented by very able counsel, and all of whom followed those guidelines for effective intervention absolutely perfectly. Let me turn to tomorrow in Ontario, and I'm just going to ask a question. 10 days ago, Ontario tabled a bill in the legislature to repeal the Provincial Public Inquiries Act and to enact a new one. How many people in the room are aware of that? This is a very sophisticated group. Nobody? It is Schedule 6 to the Good Government Act. It was tabled on October the 27th. It received second reading earlier this week. It may well pass without going to committee. The Public Inquiries Act in Ontario will be altered from a 6-page act to a 36-page act. The purpose of the act is set out in Bill 212 in the first section. The purpose of this act is to establish an effective and accountable process for public inquiries where there is a public interest to independently inquire into matters of public interest. Effective and accountable. That will, to a degree, tailor interventions in the future, I think. The Act goes on in the proposed bill to set up a variety of ways in which that accountability will take place, everything from the government setting the budget of an inquiry to setting out special provisions in the terms of reference to directing the Commission to operate according to principles of efficiency and proportionality. It will also provide for the Commission to merely consider whether or not the person proposed to participate has a substantial and direct interest in the subject matter, so that there will no longer be the right, if you have a substantial and direct interest, to participate. It will simply be a consideration for the Commission, and so on. It remains to be seen what effect that will have. But it is, in my view, likely to produce less interventions, fewer interventions in the future and less expansive ones than we have historically had. How that unfolds remains to be seen.
Well, thank you very much for all three. So we're open for questions. Doug?
Always relish the opportunity to change roles and ask judges questions. I think for most of us doing interventions, at the heart of the challenges we face are two issues, and I'd appreciate the judge's comments about this. The first is you're supposed to bring a different perspective, but on the other hand, you're not supposed to expand the issues. How the devil do you do that? And the second issue is on the question of the Brandeis brief and expanding the record. Speaking to other counsel about this, we've had a very mixed experience in how the courts treat Brandeis briefs. Sometimes they consider that's part of your role, is to assist the court in considering this additional social science evidence, as Louis Brandeis did when he invented it. Other times I've seen the Brandeis brief thrown out with practically scatological comments from the bench about how you are trying to add to the record improperly. So if we could get some clarification, it would sure help us a lot, because we are trying to help you, but if you spend weeks putting together a Brandeis brief and it gets tossed, it's a very inefficient use of your client's limited resources.
Well, unlike you, it's unusual for me to go first in these matters. I like to go last, and so that you might as well, if you're going to make a mistake, you just change the law of the country. So that's. But let me just look. I think there's the first question about getting fresh perspective, and then you can't enlarge the. Look, I think they're difficult. It's difficult to get that right. I think if you can be as candid about what you're trying to do in saying, look, there's a study that's done. There have been opportunities to put studies in or reports, summaries of reports and so on and so forth that provide a background. And I think that's different. But if you're trying to put in anything that comes close to interfering with the adjudicative facts, like in the criminal case, then that's a no-no, because I think that, as you acknowledge, is the liberty of the subject, and we really don't want to interfere with that. So I think, and the answer to your second question is also, it'll depend, Doug. I think it depends on each of these cases, how you can, in the material that you file, try to bring it to the attention. In our case, it's not the Chief Justice who does these, it's judges who take motions duty on a rota basis, and try to persuade the rota judge that there is really something of value. And there have been, I think, many examples where that kind of Brandeis brief background has been admitted. Now, maybe over time there's been some sort of tightening up in that respect. I don't know that, but I can't give you a sort of bright line answer to the questions that you pose, because I think they will depend on the context of the particular case and the way in which the material that is being sought to be introduced will be viewed by the judge making that order, and more importantly, how it's presented to that judge in making the order. But I surely do hope that we haven't given up on all of this, because I can recall many cases when this background was very, very important.
I always agree with the Honourable Frank Iacobucci. But basically the same answer. The one thing I notice on the different perspective when it's valuable is what I mentioned before, though, is the potential impact and consequences of either doing or not doing whatever it has been asked. So that's, for myself, speaking personally, the case I've seen a real value added there. I think with some of the giving background trends, you may be getting into Brandeis briefs. We don't actually get requests for Brandeis briefs in our court very often. I can't remember when the last one was. You may be more familiar with it than I am, but I probably do. I do the majority of the interventions over the last 6-7 years. And we don't get requests very often to expand the record. And the reason may be because of the tight policies we've had before. But like Frank, I would hope we haven't given up on that. If there's a legitimate value, it's not an absolute rule when we say we're not going to expand the record. There's nothing that you can do. All you can do is get up and argue. If there's legitimate value, I think that in certain cases our court will entertain it. And you may have a better chance at our court, as I said earlier, best chance at the first level if you can get there.
I'm not sure I have anything to add, Doug. The world of intervention and inquiries seems to me to be less constrained. That is, it will almost always be the case that without adding to the issues, helpful perspectives can can be brought by interveners. My inquiry was enormously well served by an intervention on behalf of ALST NAN that simply brought the perspective of the challenges of servicing Aboriginal communities in the north. I simply wouldn't have got that otherwise. In terms of the Brandeis brief, the new legislation now requires commissions to have regard for the kinds of things that go into a Brandeis brief without interventions. They got to do it. They got to look at available information. So that too may reduce the perceived need for interventions.
Just on inquiries, if I can add one comment, on the policy side of inquiries, I think it's even broader that commissioners will allow interveners and indeed ask them to tell what are the issues. Certainly tell me what the issues are for protecting drinking water. And interveners would say what the issues are. And then now let's go from there. And what can you bring to the table on that? Yeah.
We have 2 questions in 3 minutes, so if both questions can come and then the panel, in the spirit of efficient intervention, can divide their responses. My colleague, Denise Rayon.
Thanks, Kent. So a couple of questions, and I'll try to be brief. I'm interested in the comments of any of the panelists. The first is an old chestnut, but that doesn't make it not worth talking about. It's useful caution to say interveners should try to be objective, they shouldn't speechify, they should try to be genuinely helpful to the court. But, one has to wonder whether our conception of objectivity is common across the board and whether one person's truth is another person's speech. And it would be interesting to have a clearer sense of how much objectivity you think there are about these kinds of questions. I'm not surprised that the Criminal Defense Lawyers Association is always warmly received by the court and is not regarded as speechifying and is genuinely helpful and objective. And I just wonder whether some other interveners are not always treated with quite such kid gloves. The second question that I have is kind of from a different direction, and I wonder what the members of the panel think about your ability or your role in actually calling for intervention or in appointing amicus in cases in which there aren't any it's like sleeper case that's kind of crept through the system and nobody noticed it was coming along and the interveners are not there to be helpful. I think that from my perspective, the prime case in this regard is Law in Canada, which went all the way to the Supreme Court with no interventions, revolutionized the law in equality for 10 years, and then it got re-revolutionized. And all of that happening without benefit of any of this helpful intervention from various public interest groups that might have been helpful.
Okay, and a third quick question.
So I have just 2 quick questions. Sorry. So the first is, so there have been cases at the Supreme Court where the court has decided to hold a rehearing and has asked specifically for intervention. So Stillman is that case, right? And so is it not worth considering an appeal, if the appeal court has a hearing that interveners haven't identified as raising important issues of principle that extend beyond the case, and the court hears the case, does its research and thinks, you know what, we actually want to hear from a broader set of groups. Is it not plausible and in fact perhaps advisable that the court could do what the court did in Stillman and do that more routinely, right, rather than proceed without the benefit of broader submission? So that's the first point. And is there any rule? Is there any barrier in the rules of procedure at the Court of Appeal, for example, that would stop that? The second is about the role of the intervener, and that's sort of another way of getting at what Doug and Denise have said. You know, on the one hand, we say this, right, that the parties to the case own it. They are the ones who are partisans. The interveners can't be those, right? They don't own the case. They have to stand back from the case. They have to be objective. On the other hand, we all know that interveners come with a point of view. And they come on one side. In fact, they sit on that side of the courtroom, right? And so interveners can't speak in the air. They have to speak about this case, right? They're not there to give essays on Section 1 or 24.1 or 15. They actually have to speak about this appeal. So where is that sweet spot, right? So that you're not kind of just writing a textbook on the relevant charter issues, because that's not what the court wants to hear. The court's resolving this appeal, right? But you're not stepping over the line and getting into the party's business, right? So what is that point?
Cheryl's given us a few more minutes to respond to all these provocative questions. So.
Yeah, no, this is no.
Yeah.
Well, let me pick one of them. About the first one, about the Court of Appeal inviting interveners, having here. I think, there's no rule against it. It happens occasionally. Typically, when it happens, it's before the oral argument of the appeal when the issues are identified. And I think I would concede that it happens most often in that type of case that I mentioned where we're dealing with process or procedure and we invite the Criminal Lawyers Association or the trial lawyers or something like that. That's when it typically happens. As to whether or not we should be more liberal inviting them in, I don't have any objection to doing that at all. I think in practically the way it'll work is a panel who is looking at it either before argument or after having heard argument would see that there's a need. And we don't have a culture of doing it in the broader types of issues, is what I can say. Not to say we shouldn't, and maybe it's something, I think, a useful suggestion that we should look at. We get that type of help. I'll turn over one of the other questions.
We had that recent case about jury trials and whether they were unconstitutional, where the trial. Do you want me to talk about it?
As Dennis says, it doesn't really very often happen that we would, and really both of you asked a question, what if there's an objective need for interventions? How do you go about it if there are none? A recent example we had that for me is quite unique was a case in which a challenge to the constitutionality of a civil trial without a jury, that is, taking a jury away from a civil litigant, where that was raised as a charter violation. And the trial judge actually invited interventions on behalf of the Advocate Society and the criminal lawyers, the Ontario trial lawyers and so on. And they, in the end, provided very useful participation. They stayed at it. They were there in our court, too. But that would be that's unusual in my experience. It does seem like a sensible idea in the right case.
I'll just come in on the objective thing that both you, Denise, and you raised, Sujit. And let me say this. First of all, there have been, and you just have to take my word for it, there were interveners who actually said, we wish the appeal to be dismissed. In other words, they really go down to the remedy on a criminal case, or that the appeal be allowed, and so on. And that's the sort of thing. This is a question of degree. Your point, of course, interveners come in with a perspective. We know that. But they don't have to translate that perspective into sort of getting into the fight of the result in that case. They'll give the views that will lead to that result, but don't make it express because you're just ganging up. Try presenting it in the way that, look, it's saying, we know this is specific cases dealing with this, but there's a policy issue here that we can give our insights into. So it's a manner of presentation, and it's being mindful that the real point is giving information, expertise to the court, knowing that the court will know where you're coming out on this, but not particularly wanting to hear you sort of say that we, for example, we support the submissions of the appellant here insofar as they raise X, Y, and Z. This is not necessary. If you're there, you're going to give them, the court, some idea of what the policy ramifications are, the consequences that Dennis raised of going to certain rules, because we have the experience in these ways. So it's a manner of how you present, as knowing that the court will realize that you may have preference for a particular outcome, but that's not what we're interested in. So I haven't done great justice to it, but I can tell you, in certain cases when an intervener has gone too far. And the intervener will start arguing about the facts that have been misinterpreted by the trial judge. Well, that's for the parties. You might want to say that a rule that has this leads to certain kinds of misinterpretations by judges who will not appreciate the distinctions that have to be made in this respect. I agree entirely with why the Supreme Court should not ask for interveners, not just from the attorneys general. But by the way, while I'm on that, I would not be in favor of abolishing the rule of discretion, of right of attorneys general to appear. I'd be hopeful that attorneys general might use common sense and say, we really don't have to go down to Ottawa on this case. But I'd be very leery, because you see, this is a federal country. Well, I'm not trying to give you a sermon on this, but it's federalism here. They feel that, particularly on charter, it's not just the federal government's right to have an interpretation on the charter, it's their right too, because it affects them. And so I think I'd be leery of that, but I would be very much encouraging attorneys general not to come willy-nilly on that. On the point of amicus, we don't really use amicus very often. We had to do it in the Quebec secession reference because Quebec never showed up. And it wasn't easy to get an amicus because a lot of lawyers in Quebec would not want to be openly participating in a process that their government, in effect, deliberately, I mean, not just accidentally, but deliberately ignored. But we did get a good amicus, and he did a good job. And we did do an amicus on a Section 1 case where the government conceded of an infringement of the charter and just went to Section 1, and we wanted to say, well, look, there is a nexus between the violation of the charter and the justification. So we wanted to get argument by an amicus on why was the charter infringed, because there was such an important connection, in our view, between it. But we don't use amicus very, 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 the court doesn't use it very often. But, that's it.
Well, please join me in thanking this excellent panel.